I'm gonna sign in too.
We have folks on.
Is there?
It's a public hearing, so
No, but
it's
I'm-
not necessary to sign in. She's gonna open up the public hearing. We'll see for the record and then.
Thank you. So,
Worst case scenario, you do one of these,
Yeah.
I'll walk over.
okay.
Allergies are out of control.
I,
Yeah, yeah.
Thanks for sending that.
Huh?
So thanks for
Hey,
sending that.
Erica, are we,
Well, I read it.
Yes.
everyone's here? Is anyone
No,
virtually?
Yes.
I don't
Chris,
have
can
it.
you hear us?
One yesterday.
Chris is virtual?
Screen up,
Yes.
shut up. The 14th, yeah, the 4-1.
Probably we could have.
We're okay? He's on?
We're good.
Okay.
I'm here, Mayor.
Mayor Mitchell,
Here.
Vice Mayor Bravo,
Here.
Councilman Best,
Present.
Councilman Behet,
Here.
Councilman Vasquez.
Here.
There is a quorum present.
All right. Thank you. Thank you, everyone, for being here for this hearing tonight, Wednesday, March 30th. We'll do the swearing in of all witnesses.
Any members of the, I'm sorry.
Well,
I'm going by the agenda.
yeah, I think, Mayor, do you want me to, is this on?
Yeah.
Would you like me to address who's going to be a witness? Because there's a lot of people. in the
Yes,
room.
yes, please. I was going to have you afterwards to explain the proceedings, but let's do that beforehand then.
Might make
Good
sense at
idea.
this juncture. Okay, so we're here tonight, as you know, on an appeal of the city's administrative determination. UTD requested, I'll go up to
I don't think that mic's on there.
It sounded on.
that one's always a little bit challenging. Okay, so we're here tonight on an appeal of an administrative determination that was rendered by the city in response to a request by UTD. That determination was considered, as you know, by the Board of Adjustment, and the city rendered it. Let me take a big step back. UTD made a request for an administrative interpretation. The city rendered its interpretation. That interpretation was appealed pursuant to our code to the Board of Adjustment. The Board of Adjustment considered the interpretation, considered arguments of the city as well as UTD, and they rendered their decision. That decision is now before you, that recommendation rather, the Board of Adjustment's recommendation is now before you for a final, for a decision to either affirm or not affirm the Board of Adjustment's recommendation. As far as how the proceedings tonight can go, there's a few ways that it can be handled. I'm going to equate this to a court proceeding because the way that this is working is is effectively sitting as judges as opposed to in your legislative capacity. So similar to how we do things in court, you've received the city's interpretation and sort of its brief, and you've also received UTD's brief, and that's all part of the agenda package for this evening. So similar to court, there are times when we submit our arguments and plaintiff's counsel submits their arguments, defense counsel submits their arguments, the judges read the motions and briefings ahead of time, and the judge, we attorneys get in front of the judge and we're ready to argue, and the judge says, I've read your briefings, I don't need further argument, I'm ready to make a decision. That is one option that you have, where you can simply say, I'm ready to make a decision. That's assuming that the city and UTD have had an opportunity to be heard and that they're okay with that process. And we would confirm that. The other option is you can ask questions directly to city staff, and the city, Mr. Rango and Mr. Uribe are here to assist on the city side. I'm here to advise you as a council, and Mr. Fernandez is here to represent UTD. And I believe his associate Massimo is here as well. So they are available to answer questions if you choose to just go directly into questions. Or the third option is you can simply ask council to present arguments. In that case, UTD would go first as the moving party because it is their request for an administrative interpretation, and then the city would respond. I know that you have pretty extensive briefs before you. So you may want to the extent that lawyers can be brief, we can try to be as brief as possible, just at least complying with due process and making sure that everybody has an opportunity to be heard. So those are the sort of three ways that we, you as a council might approach this. Aside from that, I know that there's many members of the public here tonight. Like a court proceeding, judges don't hear from everyone who's in the gallery. This is not a legislative proceeding where we're hearing public input. So if there's someone here who is a witness on behalf of either the city or UTD and either council wishes to bring them forth as a witness, then that can be done. But otherwise, everyone is likely here to listen to the proceedings and the deliberation. I'm happy to answer any questions on process otherwise.
Anybody have any questions?
Um,
Heidi, could you just quickly summarize the three options then? So we're all.
So the options would be either you, and I'll go backwards. Either you hear full arguments from both sides with UTD beginning, and then the city responding. The second option would be you just going directly into questioning, sort of like what we expect from certain judges. And when you're before the Supreme Court, the judges just say, I've already read their briefs and I just have questions that I need you to clarify. And you go in that direction. Or you have no questions and you're ready to make a decision. In that case, I would just want to be sure for due process, for the sake of due process, that both the city council and UTD council are in agreement and feel that they've had enough opportunity through their written briefings to be heard. So.
Okay.
Through the chair,
Yes, sir.
I'd like maybe perhaps a hybrid approach to this. And by that, I mean, perhaps we could have an opening statement from the plaintiff and the defense, limited to 5 minutes each. And then we can take over from there
then we can have
and deliberate
questions after that.
individually. And then, yeah, that would be my thought, folks. I don't
Okay.
know.
I think, is that okay with the rest of the council? I think that's reasonable. I don't think we need full hearings from either side. We've gotten a lot of information. We've all had a lot of time to talk to residents, to hear from stakeholders. And I think that would be reasonable. Does 5 minutes seem enough for each side of the council, or do you think you need 10? I want to make sure. Yes, sir. And then what we'll do after that, let me just clarify, what we'll do after that is then we'll have questions. We can direct questions at either council. Is that?
Just before Mr. Hernandez speaks, I just want to point out, in case you're possibly not aware, we've already read probably at least 2 or 3 times the minutes of the adjustment where
Yes.
you and the attorneys on the other side went back and forth. So we're quite familiar with your arguments.
Madam Mayor, thank you, members of the council. Javier Fernandez, for the record, on behalf of your UTD. I appreciate the fact that you've done your homework, and I would just I prefer a hot bench, frankly. So I love questions. I'm much better on my feet than I am giving a presentation. I tend to bore people, so I apologize for that. But if we could get some leeway on the 5 minutes, next, maybe as many as 10 minutes.
Let's do
And
10.
I'd like to address
All
at
right, I
least the
think-
legal arguments, which are probably not as well developed in my formal submittal to the
I
city.
think that's reasonable for this process. Is
Fine.
that
Thank you, Madam
good?
Mayor.
Okay, so
Thank you.
let's, so we would start first with UTD. Is that correct, Heidi?
Yes, ma'am.
Yes. Okay, so go ahead and we will,
It's gonna be shared. So if you want, I don't know if you want one of your members do it, or I could do it.
Thank you.
I'll just grab one. Yes.
Yes.
Sorry.
Yes,
Thank
to the
you.
extent you're calling of witnesses. Yes.
We will not be calling witnesses, but there are folks here in the audience that are fact witnesses. To the extent that the council would like to ask some questions, I'd just like to be sworn in.
Yes,
So they're-
that's fine.
okay.
You want to swear them in? now?
Yes, any member who will be giving testimony in this item, please stand, raise your right hand. Do you swear that or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you.
Thank you. Have a seat.
Okay, go ahead, sir.
Thank you again, Madam Mayor, Madam Vice Mayor, members of the council. For the record, again, Javier Fernandez with office at 1200 Brookville Avenue, joined by my associate, Alex Simo, as well as the executive leadership of UTD and our president, Carla Hernandez Matz, who is a proud resident of Miami Springs, among other things. You do have a very difficult decision in front of you this evening. I appreciate that whatever decision you make will probably engender criticism or praise from one side or the other on this issue, as there are certainly deep passions felt about the mural and what procedure has or has not been followed. But I do want to make some very quick precatory comments just to kind of give some context. You know, UTD is a proud advocate for teachers and students in the classroom, but their work with respect to transformation goes well beyond that. You know, prior to locating Miami Springs, they were, I think, a key anchor and stabilizing force for the Biscayne Boulevard corridor. So our transformation work goes beyond the classroom and into community. We value the opportunity to work with the city and be a community partner. And so one would ask, why would UTD decide to sell out of a district that was on the upswing in Biscayne Boulevard that's now become a very vibrant mixed-use corridor to move to the Northwest 36 corridor? I think that's because, like many of our members who are proud residents of Miami Springs, we believe in the potential of this particular corridor, given the special character of Miami Springs. And we want you to know that from the outs of this process, all we've wanted is to be a partner in the process of that transformation, helping to basically seed change in what we think is a very important corridor for this community and the county as a whole. With that, by way of quick introduction, I just wanted to quickly highlight, you understand the process, how we got here, so I will not repeat that portion of the presentation. We are here at our request for an administrative interpretation. I do want to elaborate very briefly on what happened at the Board of Adjustment. I think it's very instructive. At that board, procedurally, there was a motion to affirm the planning director's determination, and that motion died for lack of a second. And there was substantial discussion, as you probably read in the record thereafter, about what to do next. I think the consensus of the board was we need to move this ball forward and let the policymakers at the council ultimately weigh in on what should or should not happen with respect to this mural and how the code should be applied. And I think that was similarly the posture of the Code Enforcement Board, which had never really dealt with the need to kind of interpret and apply law. Typically, they deal with very black and white cases of there's a violation, let's impose either an opportunity for folks to come into compliance or assess a penalty. So I think we are in a bit of a gray area. There's an ambiguity in this code with respect to whether murals are authorized expressly or not. And I think that is basically the core of our argument. And I wanted to highlight, if I may, just fast forward to a couple of slides, Alex, if you can help the clerk there, to the our legal position, if you can. Let's start with the definition of a mural. I think one of the things that why we believe the city's decision is in error is because it basically ignores what is the plain reading or the obvious meaning of the word mural, right? At the Code Enforcement Board, 3 of the 4 violations were dismissed. We think it's very clear that this is not a commercial sign, right? The city there were alleged violations were for violations of the signage code for commercial signage, wall signage specifically. But when you read the provisions, they don't apply in this context because under 15030, the definition of commercial signage, there is an express exception. But to the other part of the city's argument, which is a violation of 9351, requires you to dismiss what your eyes clearly demonstrate when you observe the mural, that this is a piece of art, that this is protected First Amendment non-commercial speech. And I think it's instructive to understand that the definition of a mural is very important here. And so we can just flip back one slide. You know, the Oxford Language Dictionary or English Dictionary basically identifies a mural or defines it as a painting or other work of art executed directly on a wall. Now, again, we're not disputing that there's more than 3 colors on a wall, but this is not just a wall. This is actually a wall transformed into a piece of art, right? Via mural. And murals are executed directly on exterior walls. They're not executed on a canvas. So again, as we'll explore later, the definition of a mural and our common understanding of it, right? What we see is what it is. It is art executed directly on a wall. If you could move forward to the next slide. Similarly, one more slide ahead. Similarly, the definition of commercial signage, I think, is particularly important to your decision-making this evening, right? In the definition of commercial signage, which your signage code desires to regulate. Again, understanding also that constitutionally, non-commercial signage is entitled to more constitutional protection, right? It's subject to strict scrutiny. Commercial signage is subject to intermediate scrutiny. This definition seeks to exempt non-commercial signage in the form of a mural or other art from being regulated under your signage code. There's been a lot of conversation about, well, a UTD did not procure a mural permit or any sort of permit to erect a mural. Well, that's because when you read section 150:30 and its subparts, it expressly sets forth which kinds of signage forms, all of which are commercial, require a permit. A non-commercial sign in the form of art or mural is not required to procure a permit. That's why we did not solicit one at first, although we tried certainly to come into compliance by applying for one after the fact. If you could move forward to the next slide, please. As you're considering these matters, you can't consider them just in a vacuum. I think it's important that you understand the body of case law that informs your interpretation and decision-making with respect to the application of zoning regulations. And the seminal case on point in Florida is Rinker Materials versus City of North Miami. And that case stands for basically three propositions. The first is that statutes have to be read in their plain and ordinary meaning, right? The words all have a common understanding, a common meaning, and they must be read black and white for their common application, right? Secondly, is that the ordinances should be given interpretation which renders the ordinance valid constitutionally, right? So everything you do as a council, when we read it and we apply it as a staff, or we're looking at it from the perspective of a potential user, we have to read it in a way that harmonizes it in a fashion that renders it constitutional. We want to give constitutional authority and deference to every action you take. We can't read it in a way that would render the ordinance on its face or its application somehow unconstitutional. And lastly, I think most importantly, zoning regulations are recognized by Florida courts as an imposition on your private property rights. They're a diminution of your rights, right? They restrict your rights. And so when there is not an express legislative intent about what the council, speaking as a body through its ordinance, was intending to do, or there's some ambiguity, courts have interpreted those ambiguities in favor of property owners, right? Again, because they are an imposition of rights, a reduction of rights, where there's an ambiguity that should be resolved in favor of the property owner. This is what I call the tie goes to the runner rule. If you're a fan of baseball, right, there's a play at first base, it's a close call. In baseball, the runner gets preference. Well, in zoning, it's quite the same thing, right? Where there's an ambiguity or there's a close call, it should be resolved in favor of the property owner. With that understanding, I'll highlight one other case really quickly, which is Miami Beach versus 100 Lincoln Road, which applied Rinker. I think it's just instructive by way of analogy to the current facts. Here, a property owner built a large multifamily building, right? It's required to provide a minimum amount of parking to meet the demands per the code for that use. They built parking in excess of that, thinking they'd have additional demand by tenants. Well, as it turns out, the demand was less than they expected, and they had surplus spaces. And so in order to monetize the parking spaces, they began to rent them out to third parties. Well, the city of Miami Beach said, we don't like that. That violates our zoning code. The owner developer said, well, where? There's no express prohibition. And so the court, in reviewing the ordinance and reviewing the facts of this case, said, well, there's no express prohibition. We understand there's a minimum requirement. The developer owner provided that and is adhering to that. The surplus spaces can be legally rented to third parties, right? Again, tie goes to the runner in this case. It's a diminution of property rights. We are meeting the minimum requirements of the code. If there's rights in excess of those that are not regulated or somehow circumvented by the express rule of law in your code of ordinances, they should be interpreted in favor of the property owner. So in this case, what are we talking about? We're talking about 9351. And really, that's the only issue before you of the four original alleged violations. And I think the reading that the city has taken is really erroneous for three reasons. One, 9351 is intended to regulate the color of exterior building walls, right? So for you to accept the planning director's position, you have to look beyond the obvious, which is that you can show the mural, that this is not just a blank wall, that this is a blank wall improved with multiple colors, that this is not a piece of art. You have to ignore the obvious meaning of the word mural, which this clearly, I think, by any reasonable interpretation is. Okay. If you could fast forward to the next slide, please. The other element of your planning director's analysis is that there's no express authorization for murals in the Northwest 36th District. And by analogy, he points to the Gateway Overlay District and says, well, in this section, there's a reference expressly to murals. Understandable position, but I think it's erroneous for the following reasons. The sections that are being referenced here, where there's an omission of a mural in a companion bonus section and the express reference to a mural in the Gateway Overlay District, This does not regulate signage. It does not say you can have a mural. It does not say you cannot have a mural. What this section intends to do is confer benefits for the provision of certain forms of public art, of which in one section, a mural is expressly identified as a form of art the city is trying to induce. And in another section, there's an oblique or less direct reference to just public art. Now, I would argue that public art is defined for the 36th Street District, if we were seeking a bonus, could include a mural. But that's not the point of today's discussion. The point is that this section cannot be the basis for one making a determination that a mural is either permitted or prohibited. It's merely a section designed to confer a public benefit for the provision of a certain form of improvement. Okay. There are other sections of your code that regulate signage. In the case of the Northwest 36th Street District, there's a reference in that section to 15030. And again, 15030 exempts murals and other forms of art from regulation under your signage code and does not require them to get a permit. The last point I'd like to make, again, to keep the presentation very brief, and I would very much welcome your questions and to have an interactive dialogue, is that we have to, as Rinker has indicated, beyond interpreting ambiguities in favor of the landowner, we have to harmonize our reading of the code so that the application is constitutional. And what the planning director's interpretation does is treat commercial signage very differently from non-commercial signage. And again, I started out by mentioning non-commercial signage is entitled to more deferential protection of the First Amendment, strict scrutiny. Okay, you have to have a compelling government interest, and whatever limitations you fashion have to be narrowly tailored and the least restrictive on that form of signage. Commercial signage is treated with intermediate scrutiny, and so there has to be a substantial public interest. It has to be a important government interest, and the regulation has to be substantially related to advancing that interest. So I just want to quickly illustrate for you what your signage codes does in terms of the use of colors with respect to the regulation of colors in commercial signage. 15030, among the many things it does not limit, number one, the number of colors or the type of colors that can be used on any signage, even within the Northwest 36th Street District, right? Secondly, it does not limit the number of colors. So if again recognize, starting from the premise that again, art is constitutionally protected First Amendment speech and is entitled to more constitutional deference, the interpretation that your planning director has rendered basically saying that our rules are more lax with respect to commercial signage and more stringent with respect to non-commercial signage. That is facially unconstitutional. Okay? And I think, frankly, you have many other issues with your signage ordinance as a byproduct of the Reed decision, which I know that your city attorney has been encouraging the city to kind of amend it because there has been a lot of case law that has evolved the regulation of content and speech. But just on this case, the interpretation would say for commercial signs, we give you more leeway with respect to the number of colors. There's no approved color palette and the total number of colors that you can actually use and incorporate your signage. And we did provide in our briefing, in our presentation below, some examples of signs that have been approved commercial signage along the corridor that incorporates certainly more than 3 colors and colors that are not approved as part of the color palette. Again, the interpretation requires you to basically suspend belief and say that what we have on our wall is not art. It's not a mural, right? It's just a wall that's improved with more than 3 colors. And that's simply, in our opinion, our humble opinion, 9351 was not intended to regulate. If you could show the mural condition, please. Was not intended to regulate this condition. It was intended to regulate the condition of blank walls, to make sure that at least the colors are somewhat harmonized on buildings along this corridor to uplift the character of the district. Now, with that, Madam Mayor, I appreciate your time. I understand the difficulty of the decision you have before you. We're here to answer questions. Mr. Hernandez-Matz is here to answer fact questions about our intentions with the mural. We did, as has been the subject of some controversy, consult through the good offices of former Councilwoman Myra Zapata, my apologies, to kind of understand and make sure that we are acting in conformance with your code. At all times, it has been our express desire to be in compliance with the city's code. We are your neighbors. We hope to be a force for positive change in this community. We want to be a community partner to this council in transforming this district. It has not been our desire nor our approach to be scofflaw operators, to run away from our obligations, to not abide by the rule of law. I think tonight, if you are guided by the law that I quickly tried to summarize for you, and you apply it to these facts, there's only one conclusion you can reach, that this is an exempt form of non-commercial signage that is permitted because it's not prohibited. And that ambiguity, again, according to the decisional law, needs to be resolved in favor of a property owner like UTD. And with that, thank you for your time.
Thank you, Mr. Fernandez.
Yes.
Okay,
Thank
we'll
you.
go ahead and listen from the city council first, and then we'll open it up for questions from the council to both sides.
Good evening, council.
Good evening.
My name is Alex Uribe with the Office of Weiss Serota on behalf of the city. And I want to kind of just keep this framed in a sense. And I want to just very quickly point out that I don't think anybody here is calling this a sign. If you've read our staff report, the planner staff report, this is being treated and this is being recognized. We agree that it is a mural. The plain language of the word mural, the way it's used in the code, this is a mural. This is a painting on a wall. So I want to just put that out of the way. This shouldn't have any comparisons to any commercial signs versus non-commercial signs. That's absolutely not what this is. This case is here, and you are all here to determine whether or not the building, that wall, is in violation of the code that says you can only paint 3 colors specified on a list that was passed by this body specifically for that district. That's what we're here. That's what's before you. Either yes or no. Is it in violation of that or is it not? I'd like to point out, and I'll point out again, that your code makes a very specific reference to what a mural is. And Mr. Fernandez pointed it out that that is not a commercial sign. Again, we're in agreement. But your code also points out exactly where.
Excuse me, one second. Mr. Fernandez, if you're going to talk, could you talk out, because I'm hearing you're talking in this. Thank you.
And the code makes specific references where they're allowed, by what process they're allowed. And it's important to note that this board, or excuse me, this council specifically put out that in the Miami Springs Gateway Overlay District, they are allowed, they are subject to design review, and they are used to comply with the creative excellence standards. This body, when passing that ordinance and when passing the same style of what we call development bonuses or design bonuses for the Northwest 36th Street district, could have done the exact same thing, could have copied and pasted that right in. They didn't. And to further clarify that that is not just ambiguity and that a tie goes to the runner, this body also passed the color palette. Specific to this district, this body said, these are the colors. You pick no more than 3, and you can paint your and that's what you must paint the outside of your building with. The question again before you here is whether or not that wall complies with that section of code, not whether it should, not whether that code should be. That's a decision for you all at another time. Is this wall in compliance with the color palette? Is the mural that is on there, which we all agree is a mural, is that allowed by the code? The city's position is that it is not. You all have spoken, you all have given the city direction on how to administer the code by telling them this is the color palette. Over here in the Miami Springs district, here, murals, you can do it. Over here, it says do other artwork. So with that, I'd also like to point out that the case that Mr. Fernandez relies on, the Rinker case that he relies heavily on, that case is very different than what's going on here. The ambiguity over there had to do with a general use that was allowed, and whether a specific use that's a subset of that or could be interpreted as being allowed had to be allowed if it was not specifically mentioned. That's completely different here, where the use, or not the use, but the murals are allowed in one district, not allowed in another. Very, very different situation. And again, one other point to mention Mr. Fernandez, where he says, well, you know, if it doesn't have an express prohibition, then you have to say that it's allowed. That's not true. You do not have an express prohibition against zoos in the Northwest 36th Street district. Does that mean that somebody could come in and open a zoo or an airport or a spaceport if Elon Musk decides to come on down? That's the end of zoning codes as we know them. That's the end. That taking that line and taking that toward its end to where that's going to get pushed. That's the end of trying to wrangle and trying to create order with the zoning code. So with that, I think we are happy to answer any questions. I'd like to ask Chris, who's on the line, in case he'd like to add anything to what we've said, and we look forward to your questions.
We're going to have questions now.
Just one housekeeping order in terms of submitting a couple things for the record for your benefit, if I may. It's not related to argument, although I'd certainly love 1 minute to rebuttal on a couple of points he made. The first is just a petition, so you're aware, signed by our commercial neighbors, 25, all of whom have expressed support for the mural. And the other thing I'll submit to the clerk is 37 petitions signed on behalf of teachers that are residents of Miami Springs who are also in support of our position on this issue, just for the record, ma'am.
Thank you. Okay, so Chris, did you have anything? Is Chris on?
Yes.
Is there anything you wanted to add? I know there's a delay.
Sorry. No, Mayor, I think Alex did a great job in presenting our the situation and our position.
All right, thank you. All right, so let's open it up for questions. I'll let anyone on the council who wants to get started, and let's ask from either side, because you can ask either
through the chair.
one.
Yeah, for the defense,
Yes,
if I
sir.
might. First of all, Mr. Fernandez, thank you for your presentation. We all certainly appreciate it. And just for the record, having umpired baseball for 32 years, there is nothing in the Major League Baseball rule book that says tie goes to the runner.
At first base?
Anywhere. You can check it if you want to.
Okay.
I'm just telling you.
I apologize.
Anyway,
I apologize for making that analogy there.
Just a minor point. You might want to strike
I
that
played
from-
football for 15 years, so
from
that probably
view-
explains why I'm not as good.
Well, this is baseball, though.
No, I know.
Okay.
That's why. I apologize.
Nonetheless, you made a statement that and I've read some on this since we've been here to have to adjudicate this, as we ought to know, relative to Florida statute. And you are correct about in the event that this were to go to court, most all of Florida statute and all precedent and case law would dictate that the advantage is to the property owner. Just to make that clear, I totally agree with that.
Thank you.
And I've researched that quite well. And the other thing is, both of you actually, Mr. Uribe as well, in your opening, talked about the definition of what a mural is and art and everything. I think to the average person to look at that, how could you possibly dismiss it as not art? Second, I'll add another adjective, if I might, to what I feel it might be. And I think it's thematic in nature. Thematic. So, and I also find it interesting that in adjustment, all of the counts on the 150 side were thrown out.
Mhm.
The only one that exists, and the only reason for our presence here tonight is for 9351, as we all know, right? So it boils down to whether you can construct or commission or do anything in Miami Springs outside of 3 colors in a specific area. As new guys on the block, I can think of no other reason than a rookie mistake that again caused us to be here, and that is not seeking a permit. I get that part. I get the city's position on this, no question about it. I'm going to reserve the rest of my time and let you folks speak. I do have a statement I'd like to make before we go to a vote, and I'll ask for my time then.
Okay,
Thank you
rather
very-
than speaking now, though, I
Mayor, if I-
think we're opening this up for questions.
Yeah.
So let's
Yeah, that's
use
why I
this
won't.
time too, so that we can, if we have any questions, any, Vice Mayor, do you have any
I
questions?
just have a small little statement, not a question. Your statement saying that because permitted because it's not permitted or something to that.
Yes, ma'am.
Permitted because not prohibited. I mean, that's a slippery slope.
So if I can elaborate on that point and the Councilman Best's point as well, really quickly, if it's helpful. So I think opposing counsel, friend and former colleague made the point of uses that, if we took our position, could be introduced into the district that would possibly be detrimental. I would say the difference here with respect to the signage code and the uses is that the Northwest 36th District has express uses that are permitted and other uses that are not permitted are prohibited, right? Your signage code has no such express prohibition on murals. In fact, the definition of a commercial sign acknowledges the form of signage, a mural and other art, and exempts it from regulation under the signage code. That's our position. There's no express prohibition. So whereas a zoo or spaceport clearly violate the use provisions of the district, our mural does not.
Vice Mayor, any other questions? Okay, Councilman Fahet,
Questions? No.
okay. I do have some questions. UTD is a really large organization. How many members do you have?
Just shy of 30,000, I believe, Mayor, right?
30,000. You've been on Biscayne Boulevard
Yes, ma'am.
for all these years, and now you moved here to Miami Springs. You built a building.
Building was built. It was
Well,
renovated
and
for us.
you
Yes, ma'am.
refurbished a building. You're not new guys on the block in the sense of Miami-Dade County.
Correct.
You're really familiar with Miami-Dade County. You're a big organization. You know that there are permits required for everything. You built the building. We
procured permits for
I'm
all that
sorry,
work.
you
Yeah.
refurbished the building and you had to get permits for
Yes, ma'am.
that from the very beginning. You sat with our city planner and with our,
No.
when you submitted the plans.
The
building was already built.
Yes, no, but I mean, for the work that you were doing on the outside.
If I could just clarify for the
you put
record, the
in new
building was
windows and
refurbished
all?
for us by a third party. I'm not mistaken.
Oh, okay.
We
She
bought
should
the
go to the
Okay,
building.
mic,
okay, I'm
Mayor.
sorry. I thought you
Yeah.
had refurbished it.
Yes.
Okay. But
But we certainly
you-
made sure that the building was
Okay.
refurbished in a way that was legal
Mhm.
and conforming with your code. Absolutely true.
Okay. You asked, my understanding is you asked a former council
Correct.
member whether a mural was allowed. So right off the bat, you knew that there was a possibility that a mural was not allowed. You were asking someone. Now, I don't know why you would ask someone, a former council member.
She was on the
Oh.
council at the time. So I'm sorry. I didn't mean to
No,
interrupt.
that's not true. Is that right?
That is not true.
Just
That's
step
not
down.
true.
My apologies.
Yes.
Okay.
So you asked a former council member when there are council members here.
Sure.
When we have a city planner, when we have, and my understanding is that, and perhaps, Mara, you want to speak to this? You told them that it was allowed. Is that correct?
I proceeded to call the city and
Why don't
spoke
you just
to
introduce
us,
yourself for the record.
Mara Zapata. I called the city. I asked someone in code, whatever. And I was told, no, there is no specific code that is required for a mural. There is no code that says anything about a mural that requires the permit. So we didn't have that. If you recall, when I was on council, one of my biggest things was always saying that our codes were so outdated. We don't have a code that applies to that, and this was going to happen sooner or later. I don't think that we want 36th Street to continue being dilapidated hotels and human trafficking, prostitution, whatever goes on there. If you go a few 2 miles down to Doral, they have murals and they have art and they have a beautiful downtown area. The only reason we have the permit for the mural in the downtown area is because pressure from developers or whoever is vested in that business pushed the city to make sure that that happened, and the city agreed to meet, and we amended that when I was on council, and we had a mural.
Let me just ask this. You were told, my understanding is,
Yes, I was.
my understanding is that when you called, you were told, there's nothing on here that I see about murals. I'll have to find out and get back to you.
No, no one said they were going to get back to me. I didn't wait for anyone to get back to me. I just said to them, there is no specific code that addresses a mural. They proceeded to invite the city, the paper, everything to their opening, thinking that what they were doing was like, there was nothing that says it was prohibited. That's why they did that at that point. The reason they came to me was at that time, being an educator, running for the school board like I was running. I had frequent contact with them. So I was just a handy person that they asked because I was there.
Okay. And apparently you gave wrong information, but misleadingly wrong. You were. But
I
still
gave
don't
information that
understand-
was given to me by the city.
Okay, I'm
Mayor,
still.
Council, if
Uh,
I can just
yeah.
interject, I want to make sure that we stay focused on what the council is here to do tonight. There's a little bit of a difference there's a lot of a difference between the code enforcement proceedings that the code enforcement board has within their jurisdiction and what we're doing tonight,
Yeah.
which is there's been an administrative interpretation of the city's code. The city council tonight is not adjudicating guilt or innocence, so to speak, of any party, whether the city or UTD. The city council's role tonight is to review an administrative interpretation that was issued by the city planner and either uphold that interpretation of the code or not uphold it. The code enforcement proceeding is separate. So I just want to make sure that
Okay.
everyone,
Thank you,
and
Counselor.
I know that was some confusion throughout. So I just want to,
Well, I
we
think
don't do this.
the reason
proceeding
that I'm
often,
going there is
so-
because we're talking about what isn't prohibited and what is prohibited, and that there was, nothing in the
If I
regulations. But
can-
obviously, if you were asking whether a mural is allowed, you realize that the likelihood is that there's a permit. So that's where I'm confused for
so
such a large
I think
organization.
it's a fair question, Madam Mayor, if I can
to-
just address it square on. And that is, again, going back to the law, we have a right to rely on the plain reading of the code. And so what does the code say with respect to non-commercial signs like a mural? Well, it says, one, you're exempt from regulation. And when you look to the list of signs that require a permit, it's not listed. So I think if we had asked no one and just relied on the plain reading of the code, I think it would have been a fair conclusion to draw. And it's a conclusion that we certainly believe is correct, that a permit's not required for this. Now, we, again, wanting to be good neighbors, wanting to not be adverse to the city in these proceedings from the beginning, trying to find a resolution after the fact, when we received the violation, approached the manager and attempted to submit a building permit. Frankly, I would have told my client, had it been retained at the time, that's not necessary based on my reading of the code. But it's something we try to do in order to put ourselves in a good posture with the city, because we do not want to have an adverse relationship with you. Our goal here is to build community with you all and be part of this community first and foremost. So I think it's important to recognize.
Let's just
Yeah.
answer with the question,
Sure,
because
go ahead.
we're
My
going to
apologies.
go on and on and on. And thank you. I appreciate that. I have a few more questions, and because right now I just want to ask questions of so you have how many members?
I think 30,000 was the number mentioned before. We represent 30,000. They're not all members, ma'am.
Okay. This is a work of art. You're saying that it's a work of art. So it's a beautiful work of art. There's no doubt about that. But I guess I'm going to ask our council this question. This is a beautiful work of art. There is no doubt about it. The message is wonderful. I can't imagine that anyone could be against that message. It's a lovely young girl reading a book. The books are, what is it? Equality and justice and very wholesome, universal. So across the board, I think we're all in agreement that it is a lovely work of art. The thing is this, if that is allowed there with those words, and I personally, I cannot imagine that anyone could find fault with that lovely work of art with the message that it has. However, if that's allowed there, then, and the premise is that the building, it was an older building and it was made nicer. Well, now I find out it was already nicer when you bought it. So you really didn't make it nicer. You bought it in a nice condition. So, okay. Pardon me? Okay, so that it was a blighted building. It was already refurbished and you bought it like that and it decided to add the art so that was a clarification I needed. But any other building along 36th Street, and unfortunately, there are several buildings along 36th Street that are not nice, that are not in good condition. So therefore, should we, and what I see here is that this is a case of the tail wagging the dog, that should we allow this, we've already developed a color palette. It doesn't conform with the color palette, and that's what we're down here right now discussing, right? Then basically any other building up and down 36th Street, whoever buys it can, and I'm asking this, can go ahead and put a mural, any kind of mural. It could be a political statement if they want it to be, right? Because art can be political, and I'm asking, and have it there across the street from across the next one over from your building, or the next one, because we've set a precedent as to this is acceptable.
It would have to be, you would, by not upholding the planner's determination here, that, and essentially what that would be doing would be saying that a mural is exempt from the color palette, that you're not in violation of the color palette as long as it's art or a mural. Well, art is subjective, right? What I might find tasteful and artistic may not be universally agreed upon. I would say that yes, you would be setting a precedent on how this interpretation. I couldn't imagine how you would apply this differently to a different property owner in that district.
And it also means that any property owner that buys there doesn't have to ask for permission from us. They can just go ahead and do it, put the mural in, and then after the fact, say, well, we'll apply for a permit now because we've already allowed this in one case. So to me, this is a really important issue because it's not this mural. And again, I want to tell you, I mean this from the bottom of my heart. It is beautiful. Every time I drive by there, I break out in a smile. There's no doubt there. I love it. I love the message. I love the child reading a book and everything. It's what I'm asking here, council, what I'm asking our council, because this is really important for the future of our city, and is that the decision that we make here tonight based on whether it's okay. And obviously there was you're a big corporation. You knew that the possibility existed for a permit. It's my understanding, even at Wynwood, you cannot put up a mural without going through a board. They have a mural board that reviews the murals and decides what can go up. So this is not something, unusual to have to ask for a permit for a mural. But that it would, that in essence, then the decision that we make here will basically determine the character and fiber of our city going forward, Northwest 36th Street, whether we are going to be Wynwood wannabes or whether we're going to try to maintain, which was the intent with the 3-color palette, and we didn't vote on the 3-color palette, it was councils before us, that the intent, the vision was that we maintain a certain character that's unique to our small town that's almost 100 years old.
Jose Arango for the record. I'd like to clarify for the board that this, I think it was stated by my colleague Heidi earlier on, this is not legislative in nature. We are applying the existing rule of law through the code to the facts and seeing whether or not the questions posed by UTD through their counsel. And if you have the agenda, the packet, this was the request for an interpretation. There were 4 questions posed. I could let Mr. Fernandez elaborate on those 4 questions. He posed those questions to the city planner. The city planner made his determination based on his reading of the code, and there's a disagreement. We're here to decide who is right on their interpretation, whether Mr. Fernandez, UTD through Mr. Fernandez is correct, or the city planner is correct.
Council, but I guess my question is this, and I'm really asking the question, is there's obviously ambiguity. We talked about ambiguity. I see it as, yes, just because we don't allow bungee jumping off the side of, our buildings, we don't have it in our code, but obviously we're not going to allow bungee jumping or rock climbing off the side of the building, even though that, that's clearly we can't, and we know that from being on the council, we can't make a rule, a law for every single circumstance. There's context clues. Context clues are in my case, there are no murals in the city, up till now. So context clues would also dictate that, that permit would be required for this. But I guess what I'm asking is the decision that we make here, and I'm asking, really determines the future character of of Miami Springs, of what is allowed as far as murals of buildings being bought and, anything being put on the outside to make it, it's better than it was before. The colors are better than it was before. It's bright pink and yellow and red, but before it was deteriorating. So all of this will impact that.
Through the chair?
Yes, sir.
I
Yes,
could answer
ma'am.
the question. Or
Yes.
Through
Is
the
that
chair?
correct? Well, let me just ask, is that correct?
yes.
Okay. Thank you.
Thank you.
What?
Were you going to say,
I-
but do you want to
yes.
add something to that?
Yes, but that's not to say that I disagree with Mr. Fernandez in the sense that, yes, we are talking about murals. Generally speaking, if it's not allowed, it is a slippery slope to say that we have to specifically say that any and everything is prohibited by the code. It's just not going to happen. You're always going to find a loophole. It's just not the way that the zoning codes are written. But here we're talking, this is specific to murals. So if we say that murals are allowed, and your question goes very much to the heart of the issues, the heart of the disagreement, or the different interpretations between the city planner and UTD. If you say that your murals are allowed, there will be some precedent because of course you're gonna have to carry that interpretation from here on out until new legislation is made. But that's a different bridge that we may cross at a different time that may result in that. But at this point, we're not there. We're just talking about what is existing and how it should be read.
And I understand that, but I think any vote, as elected officials, we were elected by our residents to look forward, to have that vision and depth of review before we vote, to make sure that any decisions we make, because our time here is very limited. We have a very limited time. And when we move on, some other council is going to come and they're going to have to live with the decisions that we've made. And I don't mean this specifically, but every single decision. So ultimately, even though we're just voting on one thing, it really has a long lasting forever impact on our city's future. One second,
Yes, please.
Vice Mayor, did you have a
Thank you.
question?
Yes. Well, I had a statement and a motion. If we're
Okay.
allowed to, and
Then let
we
me
can-
let
Mhm.
Mr. Fernandez 1 second to finish. You wanted to
Just
make
elaborate on
something to
what
what I
you
was
raised,
saying.
Madam Mayor, if I may.
Question.
So you mentioned again, I don't want us to conflate uses with signage, right? Uses, again, no argument here. The section for the Gateway Over District says what uses are permitted. Okay, this is not a use. This is a form of signage. And the point I'm trying to make is that the reason we have the opportunity to make this argument is that your code, with respect to the signage regulations that apply to this district, exempts this form of art. The planning director's position is that you disregard that it's a mural and it's just a plain wall. And so I think that flies in the face of the case law and the obvious reading of the code. I think that's why we're in this position. Now, with respect to your concern, I completely understand it. That's why I started my comments by saying you're in a difficult position, because we understand that you want to have a framework, but the framework that they've related to point to the fact that these murals are authorized is a framework where I'm applying to build something new and asking you for a benefit, an incentive to provide the art. We're asking for nothing. We're just simply exercising a right that we believe exists in the code because this form of non-commercial signage is exempt under that section of the ordinance.
But any other building on Northwest 36th Street the same thing. to
Potentially could,
happen.
and you-
Could, and
And
will.
you can remedy that in
and-
the future with an ordinance or a zoning in progress or some sort of action that would forestall anyone from coming in and taking further action. We can do that at one reading with the proper notice under Florida statute. You know, again, if that was
Well,
this
but-
body's
but this is the
prerogative.
thing is the, on your wall, what you have is equality and justice.
Yes,
And
ma'am.
equality and justice is equality and justice for all business owners, even the small ones in our city that may not have the ability, the resources, the knowledge, the expertise. You know, if we're talking about equality and justice, then it would be very difficult for us to say, oh yeah, you know, this mural will allow it, but no other murals from now on. So
Ag-
count, did any, you had
I-
a
Again,
question?
Madam Mayor, I'll just
I
close
think
really
Jackie,
quickly. You can't penalize us for
She had a
doing what's
question.
permitted today. I understand the conundrum. Certainly respect it. I understand the
Like you said,
difficulty.
it's a very difficult
but you
decision,
cannot
but
penalize my client.
no,
for
and
having come in,
we
for
have to
traveling through that
ultimately go
loophole.
to affirm or not affirm the recommendations of the board of whether it meets the color palette, which is basically what we're down to, is
The
true.
vice mayor.
I
had
think the
a-
Thank
vice
you.
mayor
Before
had
me.
something, Mayor.
Yes,
You
okay.
can come to the podium if you like. My argument is not on the look or the this or
Sure.
the that. We're not arguing content based. We're arguing the code, right? So if you say it's exempt, where do you see that it's exempt?
So 15030, the definition section.
I'm
it-
looking at,
the,
can you bring it up
I
on your
can, if you want to
PowerPoint?
bring up our
'Cause I know that you
presentation, it's right
highlighted
there.
it.
Yeah.
It's right there. You got it highlighted.
It's this one.
Yeah.
Oh, you have to. There we go.
There you go, right there.
you go.
Okay,
It's a,
So this,
so
go ahead, sorry.
if you look above, it says, however, any such writing, pictorial identification and the like which is inside a building and cannot be seen from the outside shall not be considered a sign for the purpose of this section and shall not be regulated by this section. So if you can't see a mural from the public eye from within the building, by default, you shouldn't be on the outside, correct?
No, so I think you're misreading that section with all due respect. What that section says is if I painted the same mural
Right,
on an
on the
interior
inside.
wall with the building, it's not visible from the outside. It's not regulated by the section.
Correct.
What the next sentence says is a wall mural or other artwork, which is not commercial in nature, to summarize the section, right, is not regulated by the signage section. So it exempts wall murals and other art from regulation under this section.
Because it's inside.
No, because it's a wall mural or other art, not for any
Can
reason.
can I speak with your attorney? I mean, he's putting here time for you. Let me speak to him.
Yes,
Yeah.
please.
I can't.
I'm sorry, I apologize for the
Respect
audience.
From the
Yeah.
audience, please.
I'm sorry. if I-
I'm just trying to clarify where you see the exemption, because I
you-
understand that I see that it's exempted from within the building. So, I mean, from within the building, but you can't see it on the exterior, so it makes it safe. But
Yeah,
if you
I-
get the same mural and then now put it on the outside, it's now visible to the public,
So-
so now it's an issue.
Madam Vice Mayor, if I can just step back
Sure,
one
sure,
quick
sure.
second. What your code clearly does, in my opinion, when you look at the full structure, is that it's attempting to regulate commercial signage. Okay, and in this district, there's only two forms of commercial signage, as I understand the code, that are permitted: freestanding signs, depending on the amount of frontage we have, and then wall signage. And again, wall signage, which is what we were cited for initially, clearly doesn't apply. But even wall signage, they do not regulate colors, right? So we're concerned about the aesthetic of the exterior wall of the building with respect to signage. There's no limitation on the application of colors in a wall sign, as we've demonstrated below. What they all require is thematic harmony, basically, that the colors basically are harmonious, that they create a nice aesthetic effect, right? Because I think the interest with respect to signage is making sure that it's not detracting from the quality of the district. My contention, and I think it's expressed in the language, is that a wall mural or other artwork, right, is exempt from the regulations of the signage section, right? Now what your staff is asking you to do, and the rest of us to believe, is that the mural, the wall on which is painted, is just a wall that's regulated by 9351. 9351 regulates plain walls. It does not regulate signage. Your staff, your counsel has already acknowledged on the record that this is a mural. It's a form of non-commercial signage. It is protected First Amendment speech. And your code probably has exempted regulating it because it's a very difficult area for cities to regulate. Now, you've certainly tried to incentivize it in other districts by expressly providing a bonus for it, but you've not prohibited it anywhere in your code. And I understand the difficulty that that creates for you with respect to this decision. And we certainly are willing to take a pause in these proceedings. If you want us to come forward with a variance application to approve a one-off sign, if that was the province of this board, we certainly are happy to do that. But we're not trying to upend the character of Miami Springs. We want to be part and parcel of this community's transformation, this district. We think this is a very positive addition. We came in and bought a building at significant cost to try to anchor our institution in this location because we believe in the vision that you all have for this district. But I think the language is very clear. And again, the case law is very clear. And I don't want us conflating. Your council has conflated uses with signage. Uses are expressly limited to those articulated that are permitted in the district. Signage, however, is treated under this section of the code where this definition exists. And this definition says a wall mural is exempt from the regulations and permitting as a result.
Through the chair, one last question. We're not, according to our code, I missed your name, I'm sorry.
Uribe.
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 Mr. Uribe.
You explained earlier about a part of 36th Street allowing murals so long or something like, what were you talking about with the?
I think you're asking me
I want a
where.
refreshment.
Sure. Murals are expressly mentioned as one of the creative excellence standards that can be done in the Miami Springs Gateway Overlay District. It's mentioned there and it's put there, and certainly I think we can all agree that the quote here would apply and would exempt any mural there, which I think the city's position is that it is allowed there, would not be considered a sign, would not be subject to the same regulations, which you can imagine if we went through the whole sign code would have area, size of the sign, colors, illumination, and all sorts of other regulation that would not be applicable through this clause to a mural. Our position is that it is permitted in that district, but not permitted in the Northwest 36th Street, and that's buttressed by the fact that this council, this body, approved a color palette that limits what colors we can see on the exterior of a wall, whether that be art, again, that it becomes a subjective thing. I can imagine a bright orange side of a building to be art. Who's to tell me that it's not? That answer your question?
Yes, thank you.
Chair.
Councilman
Yes.
Vasquez.
I think I know the answer to this question from both attorneys, but I'm gonna state it for the record. But first, I want to make a quick statement about something the mayor said, and I've heard other people mention. We don't want Miami Springs to become Wynwood. So wherever I go, I defend Miami Springs. When they started messing with us with the sound, and I defend Miami Springs. Wynwood is an old community like Miami Springs. And I have family that lived in Wynwood, and they're two different characters. Since the 1920s, Wynwood became a design district and the garment district of Miami. So the idea of art and color and so forth is ingrained in their DNA. I understand that. That's not us. But we saw with the last council that they did include the idea of murals. So I just want to make that distinction because it's a lot of people go, we don't want to be Wynwood. Well, no, I don't want to be Wynwood. I want to be Miami Springs. People of Wynwood want to be Wynwood. At the very end of your statement, and I think Mr. Fernandez also mentioned that, and this goes to the concern that the mayor raised, and we all have concern, right? You want to open up the doors for, this flood of murals. And I believe you said at the very end, Mr. Uribe, that if we do not uphold the planning board's recommendation, that we're opening the doors. Something to that effect. I think you used that word. And my question would be, not if we change the codes, right? So
that's absolutely right.
Right. So I just wanted to get that on the record because, and both of you had addressed this sort of similar idea of changing codes, and we have talked about these codes. On this last meeting, we talked about colors of houses. So, we are, this has been sort of floating around here. And I think what this issue has done is kind of brought it to the forefront, that we've had many conversations about adjusting our codes. Some of them are very old. So I just want to be clear on that, right?
Right. And that is your prerogative as the council to do, and it's your responsibility as the council to do. But again, we also have to be very clear and distinguish that process from why we are here tonight and what the facts are and what the code is that we're looking at here tonight.
Understood. And this is an interpretation, right? That's been made. That's what we're looking
Yes,
at, the
to whether-
interpretation made.
Which was made by our city staff and then reviewed by our Board of Adjustment. And now it's in front of us.
Yes.
Does anyone, Councilman Behet, do you have any questions? Oh, sorry, Councilman Vasquez, do you have any more?
No, I think we're at
Questions?
some point going to make some other statements.
Yeah, all right.
Before we get to it.
Councilman Best?
Yeah, I
Yes.
think I'm prepared to read my statement. This statement is directed to my colleagues. I want you all in the audience to be aware of this for the vote that we intend to take tonight. I address you tonight as a resident, a colleague, an open-minded adjudicator, and a student of common sense. I'm very well oriented as to my charge here this evening in determining an outcome. As in any contentious scenario this body has weathered since its inception, there exists an obligation to seek justice, advance the standing of the city, protect the rights of our citizenry, and mitigate wrongs. That said, why are we here? Well, we're here to decide whether a piece of artwork that was affixed to a commercial building within the city limits is in accordance with our code of city ordinances. This arose as a result of a citation presented by the city as a violation of said ordinances. As we have already seen in the Board of Adjustment deliberations, the Kramer versus Kramer litigation and subsequent wrestling of the minds toward a 3-2 vote, by the way, at which time the chair and one other member voted nay on it. This issue is not going to go away. In fact, it's right where it needs to be, in front of us. By process, we tonight have the ability to determine an outcome that will ultimately be in the best interest of Miami Springs. As a barometric, consider the very few times we have been convened over the years in this capacity as Board of Appeals. Very few, probably count on one hand. Why do you think that is? Pretty easy, because it's contentious. Let's leave out the political slants, the he said, she said backdrop, the definitions that serve one side or the other, but focus on how to achieve parity. To begin, is this how we treat new businesses and arguably long-term business with county-wide implications in our city? That's number one. Number two, does this art rendering enhance or detract from the district? I'm not one to judge art, especially a property owner's vision, which was commissioned and paid for. Number three, sometimes ordinances or legislation stand the test of time. A few times they don't. Is this one such time? In test cases such as this, do we rearrange the chairs on the Titanic in draconian fashion? Or do we study the dent in the armor and render a solution? Our city tonight, my dear colleagues, is on center stage in the county, in the state, and in the nation as a whole. Let us be mindful of this as we cast our vote and show them all that Miami Springs can exercise common sense and think out of the box. Finally, let's recognize that we, at the end of the day, are the ultimate authors of this circumstance that we're here for tonight. As such, we become the entity required to effect inclusion and endgame solutions. Let us be mindful that chastising the new guy on the block is categorically unfair and desensitizing unrepresentative by proxy, and inappropriate in nature. Colleagues, we're better than that. Let's prove it tonight. Thank you for my time, Mayor.
Thank you, Councilman. I want to, I guess, get back to the reason that we're here again is to affirm the recommendations, because I think we've all given our input. And again, I want to say the mural is beautiful. I love it. It puts a smile on my face every time I drive by it. No one is arguing with that. If the UTD had, when you wondered whether a permit was required, and again, even in Wynwood, a permit is required. And there's a board that actually reviews the permits, we would have said, as long as it's with the 3 color palettes, you have 3 color palettes. And it could have been worked out. We're talking about that UTD wants to be a partner in our community. And like Councilman Best said, and I think all of us here, we welcome all new businesses in our community. We've started a task force where we're looking to attract more businesses to our community, diversity of businesses in our community. Having your headquarters here is a wonderful blessing to us, and we're thrilled about that. But that doesn't change what the issue is here tonight. And the issue is here tonight, the affirmation of, we're a city of codes, we're a city of ordinances. Pardon me? That are totally outdated. I'm sorry. Okay, thank you.
She served, she could have fixed them.
Yeah. No, well, I didn't say yes because of that. I'm saying thank you for, sorry, quiet. So the issue here is, we're a city of rules, of ordinances, of codes. Our code, our sign code at the last, during our budget process in August, we agreed to start, we've been kicking the can for years and years and years, and no other council has ever decided to address our codes. Our codes are outdated because our city was incorporated in 1926. Well, clearly a lot of codes over the years, every 20 years, things change, we're preempted and there's changes, and it's been impossible for our city and for any city that's been around for a long time. Doral has a much easier task. They were incorporated 20 years ago. Obviously, most of their codes are pretty up to date. So the reason that I'm saying this is that a lot of our codes need to be reviewed. And this council, for the first time this August, put in our budget to start that process. We can't do all the codes at once. It's a very lengthy process, but we're starting with one of them, and that's the sign code. We decided to start there. And eventually, hopefully, future councils will continue looking at our codes and trying to update them. So that is something that we realize is an issue. However, we still have codes. We have a responsibility. All of us sitting on here were elected to, and this is a really difficult decision for all of us, because we were elected to represent our residents, represent the character of our community, the historic nature of it. And at the same token, we're expected to be progressive. We're expected to, to become better, to make Miami Springs better, to wherever we can improve areas that, that need improvement. And that isn't in any city that's the case. So, and also, I think all of us here that are here on this council, I think we realize this is not a popularity contest. It's, we have to make these decisions as elected officials. I remember taking an ethics course for elected officials a long time ago and talking about when a vote was, I really don't want to vote on this because no matter what, people are going to be unhappy. Can you just recuse yourself and not be there that day? And, the thought was, no, that's why you're elected. It's nice to be elected to make proclamations and to give awards and to, vote on new projects and stuff. But really, we're elected to make these really difficult decisions too, and to make these really difficult decisions based on the laws that we have for our city, whether they're perfect or not. They are our city's laws and codes. And to make sure that, and there are things that we need to address, and that might be where we need to go with this is look at down the road, at this process. But right now, I think what we're here for is to vote on, and I know council keeps bringing us back to that, is to vote on whether to affirm the recommendations of the Board of Adjustment and our city staff that said that the mural violates our code. And had a permit been requested, this could have been discussed before the mural was put up. And a resolution could have been made of either, complying with the color code, or I'm not sure what else. But this is after the fact. We're after the fact. So I guess I just wanted to make those statements, and I see it as there's two things we can do here. We can take a vote if someone wants to make a motion, or if you feel that with the information we've gotten, the questions that we've asked and all, that we'd like to, I guess, delay the process a little more. I don't know the wording for this. Pardon me? Continue to again give us a little more time to look into this, to evaluate this case. And like I said, it's a very, very difficult decision for everyone here. It's not an easy, I think probably all of us, we see the merits on the beautiful side of it is it's a gorgeous mural. And there's no doubt about it. And the building's very nice. And we are thrilled to have UTD here. So that's the positive. On the other side is that we have to consider our responsibility as elected officials to the city. And that if we, every time that, we don't comply with our code the way it is, and it hasn't been rewritten, then will it just be, every business and every homeowner will just ask for forgiveness instead of permission, because that's kind of the precedent that we've set.
Madam Chair?
Yes, sir.
As I understand it, we're here to determine if the planning director, in his interpretation of the code, right? And this is not, we're not debating a specific code. We are discussing an interpretation of the code. So I want to make sure that we're not trying to break laws or anything like that. There's an interpretation of the law, whether you agree with him or not, right? The two sides are presented why or why not, right? So just want to make sure that we stay in that lane, right? In the sense that there have been a lot of, as Councilman Best has said, a lot of contention about this issue. And some downright pretty nasty things have been said. And there's been vandalism committed against UTD, of which I've spoken to about this dais, because it had nothing to do with what we're discussing tonight. But and even some pretty ugly things, and even a lot of people who oppose who say we should uphold the interpretation, all say how beautiful the mural is. It's like I feel like I'm in bizarro world a little bit with this issue, and so what I know is that things have changed, right? And I don't see Miami Springs being Wynwood, like I don't see Miami Springs being Coral Gables or Doral. These places have their own characters, but it does call into question, again, my colleague, Councilman Best pointed out, whether, because it's an interpretation and it's not clear, right, specific, that do we step up and really look at this and say, we got grab the bull by the horn, right? And so that's where I am, right? I think that we're at that point, and I make sure that council understands that this is what we're trying to do. I don't know that we need a whole lot of time. That's just my opinion. I think we've read this and it's been discussed, and I'm clear on what the issues are, but I just want to remind everyone, no matter how we go, how we vote on this issue, the larger issue of our codes relative to murals and other things is still going to be something we're going to have to deal with. The Gateway Group and the city council at that time made a determination, and there's some guidance there, but the final outcome of this, the larger issue about murals and what they are and what they're not and how they can be placed is not going away, right? And so it's our responsibility as the legislative body to decide, are we going to try to make some changes here or allowances where we don't necessarily need an interpretation, but rather deal with the language and say, can this language be clarified? I think it can, because they did it with the Gateway District. That's, you know, and I will just say what everyone else has said. It's a beautiful mural, right?
And-
Just for the record, right?
Councilman Vasquez, I want to address that with what you're saying, that, and I'm saying it's beautiful. It's like when we were having the music from Factory Town. A lot of people like that music. There's nothing, you know, that it's against music. However, it's violated our city's peace and quiet. So it's not that something cannot be beautiful and desirable and valued, but that's not what we're discussing here. What we're discussing here is I haven't heard from anyone, and I've heard from a lot of people who do not want the mural there, but all of them agree it's a nice mural. It's not that. It's, you know, is this what we want in Miami Springs? Does it meet? Was it allowed? You know, was a company came in and, you know, and started doing things without following our rules and checking for permits, and something that, you know, is pretty clear anywhere that a permit would be required for this, or at least a discussion about it. So I think what we can do are two things here, is take the vote, or we can ask for continuance and look at, and if this is what, and I'm just throwing this out there, is look at having the council considers whether we want to allow murals on, and Heidi, maybe help me here, a workshop to discuss whether we want to allow murals on 36th Street, which would then allow this one and other murals too, because it's not, you know, we're talking about equality. If we allow one, other murals have to be allowed on 36th Street. I feel very strongly with that. I mean, that's the only fair thing to do. So perhaps a continuance of this while we discuss that, or yeah, I'm throwing this out there. I mean, I see it as two options.
Through the
here.
chair, if I might, Mayor, the term ambiguous, the term ambiguity, it's been thrown around tonight like candy. And this clearly is a case of ambiguity. There's absolutely no question about it. That said, as you recall, during the budget process, colleagues, we were so concerned about the degradation of our codes and the lack of attention to them over the years. And I think several years back, there was a quote made by the previous city clerk that it would cost us just shy of $10 million to bring the entire code of ordinances up to speed. Obviously, we could not afford this in budgetary sessions. But
It increases.
what we did do, and at the mayor's behest, by the way, was we assigned Weiss Sirota to study signage. Isn't timing everything? Well, we're not there yet. They have not come back to us with the report. But the other thing that the mayor said a few minutes ago, I think is significant relative to how we feel on this, if we want to call for a vote tonight. And I think we're prepared to do that. I really do. I totally agree that we should go into session ASAP and dispense this as quickly as possible in terms of a redefinition or a clarification of what the code says to make it so that this won't happen again. But you mentioned the fact about a vision. As elected officials, we have to have a vision. And I strongly, totally agree with what you said. Unfortunately, Board of Adjustment doesn't have that luxury. they must vote on stuff that comes in front of them. Here we are acting in the capacity of a board of appeals as judges, not as legislatures, as was pointed out earlier. And we have that extension, that ability to think out of the box tonight and to think, once fixed, will this be better for the city of Miami Springs or will it not? I think that's the ultimate question. I know what the code says. Again, I'll cite ambiguity, total ambiguity here. That's why teams of lawyers are here arguing the case tonight. It's that simple. I'm prepared to vote, Mayor.
Through the chair. We can go on and leverage a whole bunch of things and come up with a new ordinance. Again, are we gonna allow that many colors? We don't know. So I don't know if I want to go into another session of this and we don't know how we're gonna lay out the ordinance for them. Yes, we're gonna have to have murals. I mean, I'm not against murals, but I'm not for working backwards. There's time and there's a lot of money involved here. And again, I got over, I don't know, I would say 99.9% of the emails are non-residents. I got a handful of residents, okay? I work for the city of Miami Springs and their residents. I would like to revisit getting an ordinance for the mural, but I don't want you guys to go into this thinking that we're gonna come up with an ordinance and it's gonna fit right in like a puzzle. I don't want to make false ideologies because we just don't know. So
well,
that's where I stand with that. I'm ready to
Well,
make a
I think-
motion.
And I think that was my suggestion in continuing with this if
I just don't,
it would be something to explore the possibility of, and Heidi, help me here, of that we explore the possibility of whether we want to allow murals on 36th Street. And then ostensibly that would include that area, which area of 36th Street, and it would be, where the UTD building is. And then when we come back to continue this, we'd either have an ordinance in place or not. And that and correct me if I'm wrong here, what I'm thinking is on the grand scale of things, instead of, an exception for one. Because I have a very, very serious concern with voting for something that is after the fact, and then we just say yes. I just see this as a precedent for every other, and also for every other rule and, every other ordinance that we have in the city. Why wouldn't it be the same thing after the fact? But it's very nice, but it's beautiful. But, people like it, or, it was done with good intentions. We are a city of codes, and every other city is too in Miami-Dade County. We're certainly not something that's unique that you would think, oh, well, it was a surprise that Miami Springs, required this when it's not required anywhere else. I can't imagine this, that you would go into Coral Gables and put a mural on the outside of a building without asking for, if a permit's needed, and for asking for information. Is there someone talking? Perhaps if you could talk out in the hallway, please. Thank you. So give me your thoughts on that.
I'm going to recap the different options that this hearing could go in
Please.
tonight. And if there's other creative options, I'm happy to consider them, but I'm going to try to whittle it down to 3 simple ones. So you've heard evidence tonight. You've heard different interpretations. The context of what we're here to do tonight, you as a council, is to consider an administrative interpretation of your code. That's it. You're not determining whether or not the code was complied with in the sense of how the code enforcement board would review a notice of violation. That is a different proceeding. So what you're here for tonight is solely on the question of, and I'm going to say this very simply, and you are here to either agree or disagree with the city planner's interpretation of the code. That's it. And your Board of Adjustment has made a recommendation to you, which you are free to accept or not accept. The Board of Adjustment agreed on a 3-2 vote with the city planner's interpretation, and they recommended to uphold that. That was the purpose of their vote. And they also did that separate vote that passed 5-0 for the council to consider whether to regulate murals and how to regulate murals within the city. So with that in mind, you've then now heard evidence. You have considered all of the arguments before you from both sides. So you're in a position that you can make a decision. Your decision tonight can be either to affirm the city planner's interpretation of your code. You can disaffirm or not uphold his interpretation. You can also, as has sort of been suggested, you can continue tonight's hearing. And I think the purpose of that would be to allow the city to essentially work with UTD's council to come to some kind of agreement. Now, in any of those three options, the council always has the ability to legislate. Not tonight. That's not what we're here to do tonight. But you do have the ability, that is your function at other times. And so to the extent that the council would like to take up the recommendation that was offered by the Board of Adjustment to consider what mural regulations could look like in the city. And I'm not saying what those regulations would look like at all. We're so not there. You can do that at any time with any of the options that you're doing. I think continuing the hearing would certainly leave things status quo. In other words, the interpretation is there. Obviously, UTD's mural is there. And I think the natural next step would be that the city would, I presume that if there were a motion to continue tonight's hearing, it would be with the added condition that there be either settlement discussions between the city and UTD to come to some kind of agreement, and or it can be done simultaneously to have a workshop to consider what mural regulations in the city of Miami Springs can look like. That's sort of how I see it. I think if you need further explanation of what the options are, I'm happy to do so, but.
Mayor, I have a question for Heidi. Heidi, if we do a continuance and take time to discuss what regulations for murals going forward, let's say we put a pause on this, it would be a case of if we then, rather than adjudicate now, legislate, decide, you know what, there's consensus, the people want murals, and then we change it, then it's resolved, right? Then it would stay. And if we were to decide as part of that process, you know what, there isn't consensus, we don't want to have murals, do we not in effect end up right here again? Because their violation would still be there based on, they will have done the violation based on the code. If there's no change in the ordinance, then it would basically, we'd end up right back here, right?
Square one.
I think short of having a settlement, I'm sort of going beyond the scope of tonight. So if we were to adopt legislation regulating murals, that could, and we need to consider it, that could potentially grandfather in, assuming that the regulations work out a certain way. And I don't know how they're going to be worked out because we haven't even begun to consider what they would look like. I want to make that very clear. But assuming that you had those regulations, there could be a possibility that UTD's mural would be sort of grandfathered in. I'm using that loosely. I think then part and parcel, we would have that legislation, which would affect whatever districts and properties that it's going to affect, whether it's citywide, whether you allow murals or not in a certain district or otherwise. we would have to come up with an agreement with UTD as to whether or not that sort of resolves the issues. We haven't had that discussion. I'm happy to have those discussions if that's what the council directs us to do, and I'm sure UTD's council.
But if the council decided that we didn't want murals, we would end up in the same place
Right.
Yes, you.
at the end of that process.
If,
There would still be a violation, right?
let me split that. I'm gonna
Okay.
split hairs here for a second.
Go ahead.
You could decide not to regulate murals,
Right.
but we could also, as part of a pending administrative proceeding, work out a settlement with UTD, which would only affect UTD as a settlement of, we're not in litigation in court, but we do have a pending code enforcement proceeding where we could settle that.
Some way, sure. And for the record, I don't want to interject into your conversation, but just for your benefit, certainly my client has authorized me to say that we don't have any objection to a continuance, if that's the council's pleasure. Again, our desires that always has been, and still remains to try to work out a resolution with the city. Thank you.
Through the chair. As I mentioned earlier, I'm prepared to vote on this tonight. I don't know how many of my colleagues are, but however, I see some positivity in what the attorney and what the city attorney said, our city attorney, relative to a continuance. I wasn't in favor of that option, although I was aware it available to us coming here tonight. But the more and more I hear the way you're unwrapping it, so to speak, I see that there's a possibility, it's plausible that UTD and the city could diplomatically come together on this thing and make this happen. Make it happen, meaning we won't have to paint over the mural or that. That's kind of what I'm saying. So I at this point, I think, and in all I've heard, I would be in favor of a continuance, so as to allow that activity to engage the city and UTD. And Mr. Fernandez just made that clear that they would be available to do that. So I think that's our best out tonight. Now, I will ask one question of you, though, Counselor. 01V22, how does it go away?
I'm sorry.
Our case this evening,
Oh.
01V22, how does that go away?
I thought that was a baseball term.
No, ma'am.
You know.
No, that was meant for Mr. Fernandez earlier.
That would be a football term.
You did look it up? He's a good man. So
It's
Mayor,
Mr. Baseball. There's.
Mayor, I would be in favor of that. And if you would like, I'd make a motion forwarding that this evening.
And I would like clarity, just to make sure that what you would be directing is that this case would basically take a pause to an undetermined date. And we would be directed to engage in diplomatic discussions.
No, whatever you want to
with
call it.
UTD.
Yeah.
They're always diplomatic.
Diplomatic.
As far as I'm concerned, we
Love that
always try
term.
to be diplomatic. We would engage in discussions with UTD to see if we can reach some kind of solution. And that would be, I will discuss with my colleague Mr. Arango, who represents the city before the Code Enforcement Board, on the procedural aspects of it. And we'll discuss that with, of course, UTD's counsel, Mr. Fernandez and Massimo. But that's sort of where that is the motion for us to engage in these discussions. We'll certainly, of course, inform you of when we're ready. As you know, the only time that we can discuss these things is in a public meeting.
Yep.
So we can.
Mayor, Madam Counselor, that would be my motion.
Well, let me just ask.
I'll
this,
second
though.
that.
Okay, 1 second, please. I just want to clarify this. The settlement with UTD, the reason for the continuance is for, what I envisioned is for the city council to also, in the meantime, you would have a settlement of, pausing the case, but it's for the city council to determine, or do we want murals in that area? Because we're not talking about one case, because that we can vote on right now, whether this is allowed or not.
That is up to you. There's nothing to prevent you from next week at a regular council meeting saying, Madam City Attorney, we would like to have a workshop. So you can do that as part of this. And that's fine by me. And I think that that's a natural next step for the council to consider what regulations, if any, it should have.
But okay, to Councilman Fahet's question then, the settlement, I guess I'm confused with this process. If we ask for a continuance, which basically, if you're going to be discussing a settlement with Mr. Fernandez, we're not involved in that. But, you know, it's something,
Not
so,
directly.
right, so we're just, the only reason to request the continuance would be for us to take some action, right?
To grandfather them in.
Well, to grandfather them in the sense of changing that area.
Right, so
allowing
Mayor-
that area to have murals, which, you know, I think needs our residents to be very involved with that so that they know, you know,
Absolutely.
what we're considering, because
Absolutely.
it's a very big decision.
Yeah.
So that then if we make that decision and we say, okay, let's have a city full of murals, you know, all along 36th Street. And obviously this, the UTD site would be included in that area, geographic area. Then now if we decide during that no, we don't want murals in this, we've looked at it with time, you know, we've had our resident input, and this is something that, you know, is not what we want for the city, then to Councilman Fahet's
We end
point,
up
we'd
back
be
here.
right back here.
Unless you settle the case outside of.
But what would the settlement, I don't see what the settlement would be other than.
I don't know what the settlement would be right now
Right.
because
But
we would need to engage in.
Realistically, the settlement would be saying that UTD can have the mural and the rest of the,
I
of
think
the area can't,
speaking.
right? I
Without,
can't see another settlement here.
Madam Mayor, if I
really-
could just briefly interject to help my former law school classmate and friend. I think what I envision happening, and I think maybe it'll address your concern, is that these proceedings would pause. We would have conversation. You would act in your legislative capacity on making a determination whether or not you want murals, first of all, expressly permitted in the district or not, to what extent, how, et cetera. Maybe articulate a process as we're having conversation. That may inform whether we withdraw essentially our request for this particular appeal of this determination, because the case is resolved legislatively that way. And the case essentially goes away. And we would then go back to the code enforcement board, and we would enter probably into a settlement with the board through council on that violation to the extent it's not addressed by whatever legislative action you take. So I think we would be fine with a indeterminate continuance to a date that we could agree to in the future, and allow you to have the space to go through a legislative process. From my perspective, there's no prejudice to my client because it's not changing our posture. At the end of the day,
That's the point.
if at some point that process does not come to a conclusion that's satisfactory to us collectively or us personally, we can always ask for this matter to be rescheduled. And if you enter in an adverse ruling, we always have appellate rights to another forum. So we just would like to forego the need to appeal this matter and enmesh us in further adversarial proceedings.
Except.
Madam
and
Chair?
Councilman
Mayor, I'd
Fahet
like
just
to-
say,
Just a
I'd
point
like
of
to
order.
speak
Sir.
because I've been
Point of
quiet.
order.
Sir,
We have a motion on the floor. I just want to make sure we're
We have a first and a
discussing
second, but
much-
Ask for a
Can we call the
motion.
vote?
Huh?
Can we do a motion to call the vote or?
Well,
well, if
No,
we
she
have a
hasn't.
motion, then we have
no,
to
I
have
just want to make
discussion.
sure
Well-
there is a motion, and I want to be clear what the motion is.
Okay,
Right?
let's,
So that
But
well,
Mayor,
I think the motion,
I
the
haven't been
second on
able-
the motion, right,
think it was just
was when we
defined.
were still in the discussion phase. But are you okay? Since we have a motion,
I'd
we'll have
like-
the
I'd like to
discussion.
speak because I've been
No,
listening.
no, no,
this
but we're
whole
having
time.
if we have a first and a second, we're having discussion.
we don't have a first and second.
Right, but
So-
I-
And he can speak, yes.
But everybody had a chance to, I was giving everybody a chance. I'm not upset, but everybody was given a chance to kind of speak generally. I don't want to discuss this motion in particular. I'd like to be able to give my thoughts, and I think they're relevant because I haven't really heard it framed the way I'm thinking about it. So if you guys would oblige me, I'd like to be able to say what I have on my mind. And I'm sorry if it's a little verbose, but I've been trying to kind of save it until the end.
I think you were asked several times if you had anything to say.
Yeah, no, but I wanted to, I'm listening. And I'd like to speak to my colleagues, and I'd like to speak directly to the residents. There's a couple of them here, the residents Miami Springs. I am assuming, that everybody in the UTD is well-intentioned and well-meaning. I was very clear about my position, that I thought that it set a very bad precedent, that despite the fact that aesthetically the mural is great. It's a pretty mural. That thematically, it couldn't be more aligned to me. I am a 30-year educator. I was a language arts supervisor in Miami-Dade County Public Schools. In the ETO office, I supervised language arts in the 16 lowest performing high schools and 10 lowest performing middle schools. There is nothing closer to my heart. I am a school principal. There's nothing closer to my heart than promoting literacy for underprivileged children and minority. So thematically, aesthetically, I'm with it. I just feel that all of that is irrelevant because it sets a bad precedent because protocols were not followed by the UTD. And it could be that they're very well-meaning and it was a mistake, but they weren't. And I think it puts us in a bad position. I agree with you, Mayor, that it's a bad precedent. I'd also like to point out that I've got 200 emails in my email, all with the same subject line. Don't erase the teachers' murals. I appreciate the counsel for the UTD, but their only settlement, and they said as much just now, is we'll wait as long as you guys want to wait. If you guys decide to allow murals, then we'll withdraw our appeal, of course, because they'll get what they want. Otherwise, we end up right back here. So we're just basically kicking the can down the road. And I'd like and I'm speaking to the residents, right? I got 200 emails and 197 of them are from people ranging from Miami Gardens to Homestead. So I'd like for understanding for the people in the audience, but I'm speaking to the residents and I'm speaking to you guys. I received postcards that were mailed to my house with a picture of the mural. They were all handwritten. It was all the same. It was the exact word for word, same statement with the same grammatical mistakes, just repeated with the different people's names. The 200 emails that I have the same subject line. They're a complete copy and paste with inaccuracies and a statement, and they're all from different, but so I know you guys represent 30,000 teachers. Who used to be in the UTD when I was a teacher. But and again, I am assuming great intentions by the people in this room, but there's more people in the UTD. Obviously, I have 200 plus emails. And when I get 200 plus emails and it's a copy and paste, and each one says the mental gymnastics being performed by the parties representing the city give the impression that the only real motivation behind the actions is political. That's 200 people representing the UTD telling us that our actions are political. And if anything, to me, and again, I know you guys are well-intentioned, but if anything seems like political operatives, it's getting 200 emails from people on behalf of the UTD telling me this. It's not even thoughtful enough for them to like write their own ideas. They're not even residents. They're just copying and pasting and sending it to us. So I feel like that is political. And I just want you guys to please understand like our point of view, because I'm sure you guys have 200 emails in your email inbox also. So I just want you guys to like understand like our point of view. Unfortunately, the mural, as pretty as it is, was defaced. Apparently it triggered somebody, right? That's the worst thing that possibly could have happened, because then now I feel like it counter triggered some people. You guys are great, but there are some people on the other side, because there have been aspersions cast about like innuendo, about racism. There have been media reports that have been inaccurate. Obviously, we're getting bombarded with emails that have inaccuracies. There have been inaccurate media reports. There have been social media posts and things like kind of innuendo about racism. Obviously, I just told you guys about my background. Like that's not the case. But it doesn't feel good to be up here and have that kind of stuff thrown at us. I want you guys to just empathize with us. Okay. So unfortunately it was defaced. I thought that was horrible, but then that kind of spurred this like look, even my colleague here in MiamiSprings.com, I have nothing against Nestor, good guy, but even there was even questions. So now we get to a point where there's like the extreme sides, and we're all in the middle, guys. We're all in this together. But the extreme sides are just lobbing things and innuendo. That doesn't feel good. So this is how I look at it. And then I'm going to tell you guys what I feel. And I think it's going to be something novel because I don't think it's anything that has been discussed now. My belief, I could be wrong. So there's no need to scoff. My understanding, right? You guys have a cogent argument. My understanding was that on March 10th, they approached a former council member to ask if it was okay. I don't know why they would approach a former council member. I wouldn't encourage anybody to even approach a sitting council member. That there are people you should talk to, and it shouldn't be me about, it should be the city planner's office. And there's different versions of what happened after that contact was made on March 10th, but on March 18th, lo and behold, there's a mural on the wall 8 days later. So that, I don't know, that kind of makes some people feel like that brings things into question. I'm sure you guys are understanding of that point of view. So a violation was done on March 25th. They were summoned to the Code of Enforcement Board. They were given 90 days to come into compliance. And then they asked for an appeal. They went to the Board of Adjustment. The Board of Adjustment, they made their argument to a voluntary board, the Board of Adjustment. We're very respectful of those people that are volunteering for us. And they gave their best assessment. It was a 3-2 vote, right? So it was razor thin when they listened to it, because I'm sure Mr. Fernandez did a great job presenting it like he did here. Immediately after voting 3-2 to deny their appeal, they said on a 5-0 vote, we should be looking at our code and how we regulate it. And that's our second recommendation to the council, is that we need to look at the regulation. That tells me something. It tells me that the code is ambiguous, right? Does that mean that I think that they're still not? I have my opinion. I think they're wrong. I think we have an argument. I think our argument is stronger. But just because you have an argument doesn't mean that you should engage in legally making that argument, because that leads to litigation, which they've already alluded to. They've mentioned 3 times that the mural represents protected First Amendment speech. They've talked about appellate options should things not, the settlement means that you let us have it, because if not, we end up back here. We're just going to be kicking the can down the road, right? So it strikes me that even we've been talking all year about, hey, we should listen to our boards. The boards on a 3-2 vote said, we deny your appeal, but on a 5-0, they said, you really need to look at this code, right? So give me a second. I've studied it now in preparation for today a great deal. We have an argument. I am of the opinion, I'm not a lawyer, that the code is vague and that it's old and that it's outdated. I still think that we're in the right, but that doesn't mean that we necessarily should be fighting it in court. There's uncertainty. If we affirm the city planner's office decision, and again, that I think that's something that's important. It's a city planner's interpretation. I don't happen to agree with Mr. Fernandez's interpretation. They're saying that, well, no, there's the paint that's on the wall that falls under the color palette, but that's the paint on the exterior wall. But then there's the paint that makes up the artwork that's on the exterior wall, and that's not the paint that's on the wall that's governed by the color palette. I think that that's kind of mind bending, right? And I've got 200 emails about mental gymnastics. Okay. All right. But that's just my opinion. So we either affirm or we don't affirm, but it seems to me, it strikes me, what then? If we affirm the city planner's interpretation that was affirmed by the Board of Adjustment, right? It strikes me that we're headed to litigation, right? And my understanding of how this kind of litigation and First Amendment right litigation, it's an evolving area of the law. It's something very complicated. And anybody who knows, I've been through this. A lawyer can tell you, oh, you got a strong standing, 60-40. That means nothing. You go before a judge and anything can happen. And then we're paying for it. The taxpayers of Miami Springs, not you guys, I'm looking in the camera. So the results are potentially, results are potentially lengthy, costly, uncertain. Nobody can guarantee us what's going to happen if this goes to litigation. They don't strike me as anybody who wants to go away, right? Given, the things that they've been doing, which I don't agree with. I don't condone, not you guys, but people that are under your umbrella that are wearing are doing things that don't make me feel good. So I don't condone the way they've been approaching this. It doesn't strike me like you guys, if you guys want to be good neighbors, people under the banner of UTD have been doing some things that don't strike me as being good neighbors. This is what I believe. There's going to be some people that are upset, right? I've been very clear. You break the rules, I'm sorry, it's a bad precedent. I'm not going to go along with that, right? But I'm upset at myself because I see that we're in a pickle here, because we all have a responsibility to the residents of Miami Springs to not allow ourselves to get mired in litigation when there is no guarantee that we're going to win. It's going to be extremely expensive. And we're just here talking about kicking the can down the road, and they're not going to let this go away. And unfortunately, the code is vague. And that's why we've talked about and we budgeted like, hey, we should look at the signage code. I think we're right. But just because I think we're right doesn't mean that I want to gamble with the taxpayers' money and potentially lose and have to spend a bunch of money and have to keep fighting this, which I already, it's distasteful to me how the fight has been. I just don't like it. So those are risks that I don't want to take. I don't want to gamble with the residents' money. We have a responsibility to be prudent in terms of the decisions we make and what's going to, if we have to pay Weiss Sirota to defend us in litigation, I just don't feel like it's prudent for us to do so. So I feel like tomorrow we should start fixing this code. Like tomorrow we need to start fixing this code so we don't get put in this situation again, because I don't like what the situation they put us in. Sorry, I don't like it. I feel like I'm going to hold my nose and vote to not affirm if it comes up to a vote, just because I want to move on from this so that nobody else puts us in a distasteful position like this. And now's when I'm talking to the residents, because I don't feel like we should be gambling. Like I'm with you. I said it last council meeting. No, it's not. It didn't follow protocols. It's not right. It sets a bad precedent. But all this is doing is setting us up to put the taxpayers' money at risk and waste more of our time. And unfortunately, there's ambiguity, and I'm not going to roll the dice, or I'm not in favor of rolling the dice and potentially taking this to litigation, have this be lengthy and costly. I feel like, in my opinion, we should just vote on it. And I'm going to hold my nose and say, I want to just move on from this. That's just my thinking on it.
Okay.
Through
and
through
Councilman-
the chair, Mayor, if I
one
mi- if I
second.
might.
Councilman, I just want to mention, and that's why I am proposing the continuance, because I agree. I find it, teachers that are, it's a noble profession. It's a highly respected profession. We entrust our children to you. And one of the things that our children are at school is there are rules, and you expect them to carry rules. And no matter how attractive a child is, if they break a rule, we're hoping that, it's not that they have friends in high places, or they have a lot of friends, and their friends can all talk for them. Or, the child really never gets into trouble and it's an attractive child. And, it's rules. And yes, there are times where there might be ambiguity, but in essence, almost always in every school, we know what the rules are. And even if it's not specifically written, this is what's not allowed. This is what's not tolerated. And I find it, like Councilman Fahad said, that it's a very difficult position that we're in. But ultimately, we're talking about such a bigger decision for the future of our city and the precedent that it sets, and anyone else that comes in and just basically says, well, you let UTD do this and we'll go through some litigation. We'll apply for a permit afterwards, and we will never, ever be able to recover from this. And we've had in the past, not that long ago, of instances where residents come and complain about the wording on something, about, something that we think is beautiful, but, it offends someone. Obviously, murals have the potential for, and this is a beautiful one. I don't think it shouldn't offend anyone. But another one may very likely. I've had some business owners approach me and say, what, if this is allowed, then I'm going to have, and some of the murals that they've discussed will offend other people. And I don't know how we can get about, and we're going to spend our time here, on the council constantly hearing this. So again, I want to say this is such an important decision for the future. And it's what vision we have for our city 5 years from now of how we expect it to look. And I use Wynwood as an example because we're not Wynwood wannabes, and Wynwood by no means wants to have a gazebo in the center of Wynwood. They're not looking to be Miami Springs. Every city has its own character. Factory Town, that we've had the issues with the noise. I can see that area having a lot of murals. It'll probably be an area where murals are in every building. It fits there. And I'm going back to the beauty of it should not be the reason that it's attractive. And I hope that this is not the case in schools, that the popular child or the one with a lot of friends or the one who's attractive is the one that's allowed to, we'll just, overlook the rules. It comes back to it's an interpretation of our law, but it's our law. It's our city's law. We have employees here that interpret the law, that are paid for this. This is what we pay them to do, just like our police officers are paid to protect us. So this is what we've paid them to do. And this is their professional expertise that they're using to tell us what our law is. And then we have a board of residents that are put in place as kind of a buffer between these things so that they can review these things when there's an appeal, when there's some sort of, of disagreement by the party, the business owner or the resident. And these residents are put in place because they're residents, but they have expertise. The ones on our Board of Adjustment are very highly qualified professionals to give it a second look before it comes to us. So all of these are very important points that I think it goes so much more than, oh yeah, let's just go ahead and allow them to have the mural. And that's why I'm suggesting the continuance, because if you're saying, well, we'll be back to where we were before, well, perhaps, but in the reality, in the long term of things, another 3 months on this is not going to make a big deal. What's more important is that if the issue has come up as to whether we want murals there or not, that we allow a continuance. And again, that's why I'm saying specifically, it's not to allow a continuance just so that UTD can keep the mural. It's so that we as a city can have the opportunity to decide, do we want to allow murals in a certain area of the city? And if so, then the UTD one would be included in that area and it either be grandfathered in or it's already there. I don't know how that will work, but that's the only reason that I'm proposing this continuance, because ultimately it seems like a better option than that we're still the ones deciding whether we want murals than just saying, you know what, we're just going to go ahead and, because they're big and powerful and they have, so many residents and they sent us the 200 emails, 99% of who are not residents in Miami Springs. So we are not responsible. We were not elected to, our job is very, very clear. UTD's job is very, very clear. It's to represent teachers. Our job is very, very clear too. It's to do what's in the best interest of the community of Miami Springs. And that means our residents and our community and for the future. Ideally, it would all go together and we'd always see everything together, but we're on different sides of, what our responsibility is. So
Mayor,
my thought for the continuance is that instead of just holding our nose and saying, well, we'll let this one go, because then we'll have to let everyone go, is that we decide.
We
and
gotta
if we
fix it. We're
don't,
gonna have to fix it anyways.
well, if we decide we don't want murals there in our city, and we give the residents an opportunity to
Heidi,
to
while we're,
feedback on that, then we would be back to, yes, the same position, but we'll go from there.
while we're legislating this, Heidi, can something be done to keep people from doing a mural?
Yes, we would do a zoning in progress, which UTD's council also alluded to. So we're in agreement on that. So in other words, we would begin a process of legislating on murals, however you choose to do so. And anyone who comes in with an application to put up a mural would have to abide by the regulations that are to be set in place, not the current regulations. So
Mayor, I'd like to add, just now I'm speaking to you guys. Not only is it a bad precedent that they did the mural, and there really wasn't confirmation from our point of view. You know what else is bad precedent? That now we are having to expedite a process we got to legislate. We have to expedite a process to make a decision as a precondition of making a decision on a quasi judicial matter that we have before. That's a bad precedent, because now, hey, if you push hard enough, then we can force you to legislate. Don't adjudicate, because we're going to force you to. That's a bad precedent also.
But I think the issue is this, and I agree with you. And there's so much of this that, and again, I find it surprising, like you say, with UTD, you won't say you want to be community partners, but we discussed this. We went through if anyone wants to talk, please go outside. We went through this process. We've gone through this process as much as possible. You applied for a permit because after we gave you the notice, we said you can apply for the permit and that'll give you a little more time to have the mural up there. No, we're not going to have, thank you. We're discussing now. We had opportunity here from both council. So the difference is that, do you hold your nose and say, okay, just let them do it? And I agree with you with the emails that we've gotten. It's, surprisingly, UTD wants to be a good partner, but what I see is that you've debased us, Miami Springs, by putting this out across, of just how unjust we are, and how I'm surprised because you're in our community. You're part of us. You're part of this community. And yet this information on these emails that we were getting, surprising, but be what it is. I think the issue is, and I'm not by no means saying that we will, if we review the possibility of having murals there, that we will say, oh, sure, let's go ahead and have them. It'll be a decision. And if murals are not allowed there, if that's our decision not to allow murals there, then we will be right back here, where I guess we would have to vote again. Would have to have another hearing, Heidi.
again,
Yeah.
that is assuming that you don't settle this issue in some other fashion.
I don't see how another fashion is, like Councilman Fahed said, except to allow the mural and just say,
And
so it has to
I
be, I
sort of-
mean, in my opinion, it has to be more equitable, and it has to go with exactly what's in the mural of, of equality, of justice, of treating this on a broad scale of what this means for Miami Springs, not just because, one business came in and did what they wanted to do without asking really without being really community partners of coming to us and discussing, what was possible with something like this. But that said, these things happen. We're here because, all these situations occurred and we're here. And you're right, Councilman Fahet, do we just go ahead and allow it, or do we
I think we
do
should,
it as a uniform process to say, give us all a chance to say, do we really want murals there or not?
I think
perhaps
we
we
need to
really
have
want
that
murals there.
conversation anyways, because
Well, but
the
then
one
it-
thing we've all agreed on is this is going to open the door. So I feel like we should just start. I think we should just vote on the determination and then start tomorrow
But then
on
that
closing the
means
door.
that this mural, I don't understand that, because then
And
this means
unless
that
the
this mural
settlement
is.
involves them doing the mural using 3 approved colors on the palette, I don't see what other compromise there can be. Maybe you could thread that needle. I mean, I just,
Compromise might be that we decide that we want murals. I guess
Yeah, I
that's
mean,
one possibility,
that would be
right?
great.
Okay, and then we'd all be kumbaya amicably,
But
I mean,
I'd rather
but-
engage in that process without getting bombarded with emails and having hit pieces in the media like
Yeah,
talk about us.
that-
I'd like to engage in
Oh,
that
and I
process
agree that
without
that's
without what's
surprising
happening.
from, really surprising, particularly when you're in our city, when you bought
point
in
of
our city
order.
and you want to say you want to be good neighbors, but
Mayor, if I might,
it's
I
happening.
would like at this point, and Councilman Fahet, thank you for your insightful presentation there. I'm going to change up tactics here and withdraw my motion. And I'm going to make a motion that we deny the city's position on this.
Wait a minute.
That's
Okay,
my
is there a
motion, Mayor.
second?
That's my
No,
motion.
just a clarification, Council.
Clarification? Oh,
Yeah, just clarification on, your motion is
my motion is to deny the city's position.
the city's position.
Do
or
not
to affirm it,
not
not
affirm.
the administrative recommendation.
Exactly. And if this needs to be a second motion, you can educate me on that, and that we enter ASAP into special discussion amongst us, about the city council, on what we're going to do about this going down the road. That's my motion.
When you say this down the road, you mean regulations related to murals?
Yes, Counselor.
Is there a second?
Second.
Any more discussion? I just want to, my position is I don't understand why we would allow this and then enter into discussions. The whole purpose of.
Because,
this-
Mayor, we are the ones that caused the problem. That's why.
No, I don't
Through
think
the
that's it.
chair?
I don't.
I
think so.
disagree.
I don't think that's it.
Okay. Any more
So we got a different motion.
discussion? No?
The ordinance.
I think we still have the motion.
We didn't
Motion
cause-
still.
Any more discussion? Call the vote, please.
Vice Mayor Bravo,
No.
Councilman Best,
Well, wait a minute now. Whoa. We're talking about the city's position on this, yay or nay, right?
Presumably your vote on your motion would be yes.
Yeah.
Which-
Aye.
Yes.
Thank you. Sometimes these
Yeah,
things.
I know.
It's
Have
confusing.
it-
You say yes.
I'm
and
with
it's no,
you.
or you say
Councilman
no.
Fahet,
Yes.
Councilman Vasquez.
Yes.
Mayor Mitchell.
No.
The motion carries.
Madam Mayor.
Hmm?
You guys weaken the country today, Kathy. That's what I.
Thank you.
need to
adjourn.
Mayor, you adjourn?
You need to adjourn the meeting. So
Oh, I'm sorry. Meeting adjourned.
Yeah. Now we got to fix it.
Yeah.
Alter.
Yeah, no, we'll be talking.